You've been arrested for operating under the influence of liquor in Massachusetts. And if that has happened, then you're going to be facing a court process that's going to begin with your arraignment. Now, ordinarily, if you've been arrested, brought to a police station or a state police barracks, a bail commissioner is called. That bail commissioner sets usually personal recognizance, meaning you're released on your promise to appear in court. You pay a $40 fee and you go home. Your next scheduled event before the court and your first scheduled event is the arraignment date. The arraignment date is literally when you appear before a judge and the charge operating under the influence of liquor and any other associated or related charges from that event are read to you. At the district court level in Massachusetts, the only thing that is going to happen at your arraignment is that the court is entering a not guilty plea on your behalf. A judge sitting in Massachusetts is not going to let you do anything other than enter a not guilty plea. They want to see that you have an attorney. They're going to allow you to apply for either a court-appointed attorney, or they're going to give you an opportunity and give you plenty of time to go out, meet with, and hire your own lawyer. It is not critical that you have an attorney, therefore, for purposes of your arraignment, because, as I said, they're just going to enter a not guilty plea and then put the case over for the next scheduled event. Before you get to your arraignment, however, when you do arrive in the morning at the district court, whether it's Lowell or Ayer or Waltham or Peabody or Lawrence or any number of district courts throughout Massachusetts, when you get there, you check into the probation department. The probation department does an intake. They gather some biographical information. They're going to ask you whether you have a prior record of arrest in the Commonwealth or any other state, so you do need to be prepared to answer that question. They're going to ask you whether you're applying for a court-appointed attorney or whether you plan to hire your own. And once they've gathered all that information and created a record or a file for you, they'll send you to the arraignment session where the judge and the clerk will call the case and enter the not guilty plea. The next event is a pre-trial conference. That is usually several weeks down the road. It can be anywhere from 2 weeks to 6 weeks down the road. In between that arraignment date and that pretrial date is when you want to go out, meet with an attorney, spend some time with an attorney, make a decision about hiring the right lawyer. At the pretrial hearing, you and your lawyer appear. It's non-evidentiary, meaning there will be no witnesses, there will be no testimony. The arresting officer is never going to be present. The pretrial hearing is an opportunity for you and your lawyer to go in. Your attorney will be seeking discovery. Request made to the court to order that the government, the police, the DA's office hand over items and pieces of evidence, whether it be a booking video, a police report, a witness statement, a 911 call or recording, information about the arresting officer's field sobriety test training, information regarding the breath test device or any blood test or chemical tests were done. Then the matter is put over for either a further pretrial hearing or conference or what is called a compliance and election date. And literally, compliance means has the government complied with and given all of the information and discovery that was ordered by the court to the defense so that we can prepare for your trial. If they have in fact complied and supplied all of the information and discovery they were required to do, then you are going to elect the next event. And so at that compliance and election date, if discovery is complete, you're going to be electing either an evidentiary motion date or a trial date. Evidentiary motion meaning motions to suppress whether certain items of information or evidence is going to be admissible, items that were found during a search of the motor vehicle, whether the stop of the motor vehicle in and of itself is a legal seizure, whether statements that you made are violative of your rights under Miranda. All these are evidentiary issues that need to be decided by the judge before the matter proceeds to trial. And at that motion, there will be testimony. There'll be a hearing, typically involving testimony from a police officer who will be cross-examined by defense counsel, and then arguments are made to the court as to what evidence is going to be admissible and which evidence is not going to be admissible at trial. Then the matter in Massachusetts is going to be scheduled for either a bench or a jury trial. You have the right to both, meaning you can have a jury of 6 persons selected from the community serve as a jury of your peers in any OUI case, first offense in Massachusetts, or you may choose to waive the jury trial and proceed to trial with just a judge. In the jury trial, the jury decides the facts, renders a verdict, and then the judge instructs them on the law and ultimately imposes a sentence if there's a conviction. With a bench trial, the judge hears and decides the facts, renders the verdict, decides all issues of law, and then imposes a sentence if there is a conviction. This entire process through the district courts in Massachusetts, depending on which courtroom you're in my practice, I go from Hampshire County, Worcester County, Essex County, through Middlesex, down through Suffolk and Norfolk, pretty much all over the Commonwealth. And typically I see a case track from an arraignment date to a final trial date. It can be anywhere from several months to over a year. So you're going to be invested into this case for a long period of time. Please make a good decision when hiring an attorney to help shepherd you through this entire process, hopefully successfully to the end.